from Mr. Jones's behavior has been a complete smear campaign against my client, no matter what.
Good morning. This is the time set for case D216357772D. We have in court. Let's start with counsel for intervenors. Go ahead, Ms. Dwiggins. Go ahead.
Dana Dwiggins and Ross Evans on behalf of intervenors, Julie and Paul Page.
All right, Mr.
Morning, Your Honor. Thomas Standish on behalf of the father, Dylan Houston.
Yeah, and I see Mr. Houston is on Zoom. And then I believe we have Mr. Jones.
Yes, Your Honor. John Jones, bar number 6699, appearing on behalf of Lexi Page.
All right. I inherited this case, so I'm educating myself as we go along. First thing, and it will have an effect with regard to the Dr. Collins issue, is Mr. Jones, you owe me an order from the July 7th, 2023 hearing, in which, according to the minutes, it was stipulated that Dr. Collins' report would come in without objection based on hearsay or foundation.
Okay, yeah, I was confused as to what order I was required to prepare based upon recent events, because I didn't think I was. So maybe that was the issue. I think my staff might have thought July 23 or July 7, 2024 and couldn't find anything. So I'll track that down, Judge, and I'll get it to you.
Right, the trial setting parts of the order are obviously moot.
Correct.
But that stipulation regarding Dr. Collins' report may or may not be relevant to us going forward.
Since no report seems to have been prepared, I'm not sure that it will matter that much. However,
yes, and that's
I'll make sure that order gets down to you, Judge, and I apologize.
All right, and this is lots of unique things about this case, but the unique thing with regard to Dr. Collins and the nature of the motion in front of me is we definitely don't try to hold our third party outsourced providers in contempt. We have such a limited pool as it is, but the procedural history in this case regarding this issue is on April 14th, 2022. Dr. Collins was ordered to do a child custody evaluation with recommendation, and I believe both parties were supposed to pay 50% of the cost of that. And then, for reasons that are not clear, the evaluation report was not completed and submitted to the court before April 8th, 2024. And then at the hearing on April 17th, 2024, Dr. Collins was ordered by Judge Henderson to release her file and records, including her report, to the court, but there was no deadline set in there. And then on May 1st, 2024, a formal order was entered, and Dr. Collins is on the electronic service, so she was served with that order. Then on May 15th, 2024, there was an email from Dr. Collins to Department R's law clerk and to all counsel, and stated that there was no report to provide, but her chart, and that's the word I'm putting in quotes, that's the word she uses, chart. Doctors talk differently than we do as lawyers. Chart would be ready to deliver to the court this week. And again, for reasons that are not clear, it appears that nothing was ever received by the court, and I confirmed last Friday with Department R that they had not received anything from Dr. Collins' office. And then this morning, we did receive both. I guess that we were copied on an email that went to all counsel regarding her appearing today, and then I believe there was a letter addressed to Judge Henderson this morning from Dr. Collins that I believe all counsel has received. Is that correct?
Yes, Your Honor.
That is correct.
All right. So we understand now why she explains why there was a delay in the records and that she can submit her chart. Apparently, we can have it by next Monday. That's my understanding from this. And that's if we don't want her, and it may be relevant, it may not be. Her hard file is going to include all of the documents that were submitted by both parties. since April 14th, 2022. So with the status and with changes in counsel and stuff, I don't know, you may need that stuff. Mr. Standish, you may need to know what was provided on behalf of your client to Dr. Collins. So I don't know if you need that.
Well, it's a larger discussion, Your Honor, of the nature of Dr. Collins' file as to its admissibility and on several points. And when you're ready for that argument, I'll be glad to address those points.
Well, I was focused on getting us all the information versus whether it's going to be admissible at trial, what we can do. Obviously, at least some of the parties, maybe all of you, would like her to finish her work, but my understanding, based upon my knowledge of how these custody evaluations go, that there was probably psychometric testing done of both parents that would be included. That there'd be collateral interviews that may be relevant information still. Some things such as mom's psychometric evaluation probably would not be relevant anymore. So I think that I think that counsel for both interveners are looking for what is still relevant and useful there. I don't know, that's a separate issue, is whether I can order Dr. Collins to do a report when she hadn't finished a report. That's again, another issue. So let's talk about first what we need from Dr. Collins, what we for sure want to get. And I didn't make the order. Mr. Standish and I did not participate in the April 17th hearing. So that's where we are. Go ahead, Mr. Standish, we'll start with you.
Well, first of all, Mr. Jones just made my point for me. Mr. Jones, I know, believes that he can interpret those types of the MMPI and the psychological profile, those standardized testing, which he cannot. Nobody can except an expert, and it would have to be Dr. Collins. So what I'm saying is this file likely could contain conclusions and comments by Dr. Collins, none of which are actually her opinions in a formal report. So on the one hand, if the information is prejudicial to my client, which is, I know what Mr. Jones, and I assume Ms. Dwiggins also, but Mr. Jones is always after everything negative on my client, because this entire case is from Mr. Jones's behavior has been a complete smear campaign against my client, no matter what the facts are. And so under that scenario, what would happen is there's something prejudicial in the file, and now the other side, I guess, gets to use it against my client, probably distort it, because Dr. Collins may not have thought that was very important, but we don't have her final conclusions, and we won't. She said she could not do a report in her previous correspondence, according to my understanding. And that would put my client at a disadvantage because the pages aren't a part of Dr. Collins' file. So I don't know about any positives or negatives on them because they haven't been a part of this. Secondly, the information contained in Dr. Collins' file is at least a year to a year and a half old. She hasn't done anything in a really, really long time to gather any more data. So now it's so out of date that it's prejudicial to my client just on that basis alone. Once again, I'm not saying if Dr. Collins did another report, which would bump the trial date, and I don't think anybody wants that. I'm not saying she would find all kinds of negatives on the pages. I don't know that to be true. I just know that it would be that way for my client. If there were a lot of positives by Dr. Collins in that file, and now I want to introduce all that information about my client, then the pages are left out, quite frankly. They don't have Dr. Collins saying good things about them. They don't have anything from an expert. So I'm just saying, I'm concerned about the level to which the court would rely, or should rely, or shouldn't rely on the lack of a report, yet the backup documents in a file without any conclusions, or as to the weight of those facts in Dr. Collins' opinion as to parental suitability and so forth. She made a point in her earlier correspondence of saying, I did an evaluation in terms of without a final report on mom and dad. Well, we do not have mom anymore. She is gone. And so the point is, how should it proceed from there? I also think that, Your Honor, again, we're not looking to continue the trial date, but I just have a problem with this. If everything in the file is going to be released, then does it, I mean, I assume it still has the court's order that it's not to be disseminated without the court's permission, since we usually just get a report, but usually it has attachments. So I don't know the level of confidentiality there. But I assume we can look at the stuff, Your Honor, and then I guess we'll have a huge motion in limine hearing before the trial over its admissibility. Which we should do right away, in my opinion, if we can. And if the court wants me to file that, then I'll guess have to do it, assuming. I mean, I just don't think anybody can use the MMPI and other results without an expert to testify to them. And I think it's a little late to be bringing in experts for that purpose. And I don't have MMPIs on the pages. So that's my point.
Oh, Mr. Jones, who wants to go?
Well, yeah, who wants to go first?
You can go ahead, John.
Well, my only comment, Judge, is we're not here to talk about the evidentiary value of what's gleaned from Dr. Collins's file. We're here to talk about getting the file, right? You know, and then we all have to deal with positives and negatives from the file because none of us knows what's in the file. And I'm sorry, I disagree. I believe that the raw MMPI data, if relevant, is something the court can consider just based upon the way the MMPI is crafted and the report regarding, you know, significant issues is generated. However, I understand what Mr. Standish is inclined to argue, and as this court knows, I'm all about every document having, you know, evidentiary quality to get into evidence. So we don't know what we're going to get. The issue, as far as I perceive it, is just, can we please have, you know, the testing? Can we please have whatever documents have been provided? Because frankly, in this case, the types of documents that may have been provided by Mr. Standish's client, you know, could be as telling as anything else in the case. So I don't know that the argument that was just made is appropriate for today's proceedings. Today's proceedings were mostly to compel a third-party witness to give us the documents that they have already acknowledged exist and can be produced regardless of the delay, regardless of the lack of explanation as to why it took so long and why no report was issued. At this point, we're past that. We just want to have, you know, a lot of what she'll probably produce are filings in this case. But to me, the MMPI results could lead to the desire to have a Rule 35 examination and nobody, I agree with Mr. Standish, wants to continue the trial in this matter, but you can't say that the evidence gathered is not relevant if it pertains to dad's fitness, because dad's fitness is primarily what this case is about right now. That's all I have to say.
All right, and Ms. Dwiggins, you want to add anything?
Sorry,
Go
yeah,
ahead.
just briefly, and listening to Mr. Standish, and as you can see, there was a lot of confusion as to whether or not she in fact memorialized an actual report, but obviously she has not. We need a report. I mean, this was done and ordered by the court for a reason, and if she's not going to finish a report, and as Mr. Standish says, there needs to be evaluation of my clients and a more updated one, then either she should undertake that, or the court should order someone else to do it. But it is relevant. It had a purpose. It still has a purpose, and it should be done.
Your Honor, may I just comment as to what Mr. Jones said? With respect to the personality inventory and the MMPI results that I assume are in Dr. Collins' file, I disagree, and this is the point I'm making, maybe this is for later on a motion in limine, but I disagree that a person who is not trained like a PhD, which is a heck of a lot of intense training on this level, can interpret those. As Your Honor probably knows, they show levels across the board of all personality components on a person. And if we all in this courtroom took those tests, I guarantee you nobody, especially Mr. Jones and I, would have levels that are all the way across. Everybody spikes. And those don't mean you're abnormal. I assume, and I've never seen this, but I assume that if you were schizophrenic, you would have a spike that would go, extremely high if the report is good. But those reports measure so many different things. For example, those reports measure how much a person tries too hard to make a certain impression, and they may exaggerate or not be totally honest about some of their own views or things that have happened to them. That doesn't mean they're less credible, but I can just see Mr. Jones. I understand he's my whipping boy today, but the way he's been so aggressive in this case to date, I can see him misinterpreting to the court what those things mean. They don't mean you're dishonest. They just show that you may have tried too hard to make yourself look better on the test. But that's how sophisticated these tests are. And that's why I'm saying, I guess in that sense, I agree with Ms. Dwiggins that we need a professional to interpret them. I do not want everybody running off and making, and again, I still think this is an unusual case. And so I don't mean to make it more difficult, but if in fact all that information is going to be used, that means the burden's on me in a very short period of time to investigate everything in the pages' lives. I guess I'll take their depositions and try to go back through everything and go over every bit of their lives to see if I find negatives that are there. I do not expect to find that. I'm just saying my job would be intensely difficult where all this information is ready, even though it's a year to a year and a half stale, I would have to supplant that. So again, I think it's difficult and I'm willing to file a motion in limine here.
Everything about this case has gotten so complicated. And things might have been different earlier. But when we have experienced counsel across the board as we have here, I definitely don't like to get involved in the discovery. But I also have an order from Judge Henderson I have to enforce because nobody filed a motion to reconsider it. So my inclination today is that I'm going to order Dr. Collins to provide her chart, which she says she can do by Sunday. So we would have it Monday morning, the 26th, and I will release it to counsel. But that won't include all the documents given by either side. I'm not going to get into that. I'm going to let anyone that wants to go through the subpoena process, subpoena those records from her and go through that process if you really need them.
But we did, Judge.
What?
I mean, the subpoena to her was for her entire file.
I understand. And that, I mean, if you want me to order her to produce all of the stuff provided by either party, I can do that, but she's not going to be able to do that by Sunday. That's all.
Well, I'm okay with it being, I guess, staged then. By Sunday, she can produce her chart, which I hope includes, the psychological testing and the like. And then produce the remaining balance of her file, which all should be scanned and digital and easy to either send an email or push the word print.
Okay, so I'm going to order her to provide what she can provide electronically by this Sunday, August 25th, and then to provide as soon as possible all of the piles of documents that both sides, both parents or their counsel submitted to her for the custody evaluation. May still have some relevance. Some things are not relevant that would have been relevant in a custody fight between two parents are not relevant today because we don't have two parents and we have a much different standard because we have non-parents fighting a parent on custody. So that's much different. And also unsuitability under either the 125D or under 159A is a very contemporaneous determination. So say somebody had a substance issue a year and a half ago, they may not have it today. I don't know if you guys have enough time to do discovery with all the things you want to do, because you're out of time. I agree with Mr. Standish that litigated this enough and had it litigated in front of me enough that you can't take those raw computer generated reports from the MMPI 3 and simply read them. They're much more complicated than that, and to have an interpretation, and you guys are out of time if we keep the current trial dates to retain an expert and get an expert to make an opinion regarding what may be gleaned from dad's, because dad's the only party that would have that. But anyway, today we're getting Dr. Collins' records. I'm going to order her to produce that. I'm not going to make an order as she requested regarding the funds, because she has the right to charge you guys for copies on that. If she's making copies of hard copies, I mean, I've seen cases where each side's providing like 5 inches, 6 inches of hard copy documents. And I don't know if either of you know what was doing that, especially Mr. Standish, since he's taken over representation of Mr. Houston. I don't know if he knows what was submitted on behalf of his client. Mr. Jones may know what was submitted on behalf of his client, or may not, because he had co-counsel too. You can't help us with anything. So I don't want to have to hold Dr. Collins in contempt, but she has been served with everything, including the May 24th, 2024 motion filed by Lexi Page and the OST that was granted on August 7th. That was all because she's on the electronic service. She was served with everything, because that's the first thing I looked at when I briefed this, is whether I could take this off because there's not proper service. Because you have to have a valid order, notice to the party, ability to comply, and was the failure willful. In light of, we have a left side file, Dr. Collins' August 19th letter. So that is part of the record, but not something that's going to be able to be accessed by anybody but the counsel for the parties. So I'm going to make an order that she produce her chart that she can do electronically by this Sunday, and then produce as soon as she can after that. I'm going to give her, I mean, if you did her a subpoena, and you said you already did, Mr. Jones, but let's say we served her with a subpoena today, she would normally have, what, at least 2 weeks to
Yes.
respond? And with the holiday, how about I just give her a deadline of September 6th to get the court? I really don't want all the documents. I mean, she's
I
gonna
would just say
electronically.
get counsel the remaining documents.
Yeah, give you all, yes, I don't want them. I imagine they're gonna be, I don't know what they are, so I'm not gonna anticipate what they are, but I'm gonna order her to provide them to all the counsel in this case by Friday, September 6th. Does that work? As everybody think that's reasonable?
As long as your honor has a subsequent, a supplemental order attached to that, which is not one word of those documents. I'm assuming they would be the same as the report if Dr. Collins had rendered a report. And since the courts have seen fit to open up this entire case to the press to read every single thing that we've got, I do not want any of them filed until the court has the opportunity to rule, at least on my motion in limine, which they shouldn't see them if they're not going to be admitted as an exhibit at trial, meaning the press and the public. If we could please have that be a secret, just the same as, you know, the.
Actually, and Your Honor, I agree with Mr. Standish that these documents shouldn't be part of a court file that is now discoverable pursuant to a prior court order. Thank you, Tom, for pointing that out.
Yes, so what I'm going to say is the electronic file that the court's going to get will be released to the 3 attorneys. And it's under the same rules, and they keep changing the numbers.
It'll be left side file, right?
Right, left side filed, and it will be produced confidentially to the 3 counsel, with them ordered not to release a copy to their clients. Other clients can review it, but they're not to release a copy, treat them as we would any confidential report. As far as the underlying documents that she was provided by the parties, those can be produced directly to counsel, but counsel are not to file them with the court They can use them as proposed exhibits at the time of trial, and we'll get to that, but let's not file any of them. Some of them are gonna just be repeat of the motions and oppositions and stuff, because that's what you typically, the attorneys produce to the expert doing a custody evaluation would be copies of the motions and stuff that are already on file. But if there's other documents, there might be correspondence between the parties, things like that, don't file them. But we'll consider them if they're relevant, they'll be considered at the time of trial. Do we need any other orders from today?
Your Honor, the only other thing I asked for is, can we have a status check on Monday, just because she has obviously demonstrated disregard for court orders in the past, and what she has informed the court she would do back in May. And I don't have any confidence we'll actually receive them by
Yes.
Sunday, as she stated.
I will set a status check. How about on the 9th? To make sure you guys got everything? Or do you want me set, you're talking about next Monday?
I'm more concerned about her chart.
Okay,
So if next Monday is possible, and we could obviously inform her.
okay.
I
So-
thought the order was produced by Monday.
So she said she can produce it Sunday, the 25th. So we could have a hearing on the 26th. Or I've got to shove you in somewhere. I mean, I could do 11:30 on Monday, the 26th, if we need it, and then you guys can all tell me if we got it. If we got her chart in email and we provide it to council. Also without a law clerk until the 27th, so my JEA is doing all of that job, so be patient with us, but I'm gonna just, unless there's an objection, we're just gonna email council what we get
That's fine. Your Honor. I have no.
with that. And then I'll send you also our normal release form that we have council sign when we release those kind of reports, so that we have that in the record as well. So my hope is we don't have to see each other on Monday, the 26th.
Agreed.
Now, if you want me to also set a status check on September 9th to make sure you guys have got the other documents, I can do that. That calendar is more open. Do you want that?
That would be fine.
Because also, I mean, you guys are gonna have to hopefully have stuff in your hands and have to make a call as attorneys on whether or not you guys need to continue the trial because we need to get experts involved, or we don't, and you got everything and we can go to trial. That's my hope too. So I can set you in a second status check at 11 on Monday, September 9th.
Thank you, Your Honor.
And then with
That's
the
great.
understanding that if we don't need either of these Monday status check hearings, you guys will let me know. So we don't have to do them. We
I'm
don't
sorry,
need
Your
to
Honor,
charge.
What was the time for the 26th? Is it at 11?
What did I say?
11:30.
11:30.
Thank you. Sorry, I missed.
Sorry, 11:30 on the 26th and 11 a.m. on the 9th. And like I said, if we don't need them, just let me know, because I'm happy to take them off if we don't need them. I'm happy to have them if we can resolve something. We need to make sure that my goal is to get this trial, keep the trial dates and get this resolved for everybody, one way or the other. And did you guys come to an agreement on somebody you're going to use to try to do a settlement conference?
We did that on Friday, Your Honor, so we are, I
Okay,
think, planning to meet again.
Okay.
Yes.
We're still technically in mediation, is how I would characterize it, Judge.
oh, that's perfectly fine. I mean, I'm always happy if parties can resolve things themselves because I'm limited by the law. I have to make calls the law says, and nobody may be happy with what I decide. Whereas some compromise may end up with a win-win for everybody if you guys can get there. I don't know the issues on that. And then we have, of course, the guardianship of the estate is set at the same time as this hearing, unless there's going to be a stipulation on how we're going to proceed with that. But that's, to me, is a much simpler issue.
And Dana and I, Mr. Dwiggins and I discussed possibly moving some of the dates on your trial management order. I haven't had a chance to talk to John about it.
Okay,
But I assume we may try to do that. The court wouldn't have a problem as long as we agree, correct?
right. Just send me a stipulation on whatever you do agree on, if you're moving the discovery cutoff or the pre-trial memos, whatever the council want to do. I have a standard order, But if something works better for you guys and you all agree, I'm happy to sign that and move those deadlines for you. Especially if we can keep the trial date and get this case resolved for the parties. Or if you guys can settle the whole thing, I'll be a very happy camper. But I know it's not, this is a much different trial than originally anticipated between the two parents. So, and that means that, and if I wasn't clear before, the intervenors are gonna go first, because they have the burden. So, and then whatever, somewhere in there, we can talk about if we need to present some evidence regarding who should be guardian of these two children's estate. We can do that too. All right, anything else we need today? Who wants to prepare the order? Who can do it quickly and get it served on Dr. Collins?
We can, Your Honor.
All right. Ms. Dwiggins will
Is that okay
do
with you?
that.
Yes, thank you.
All right, because we definitely need service if we're going to have further proceedings with Dr. Collin, and I'm hopeful we won't, that she will get you guys, and that's what we need, and that will end her. And then you guys will have to, you guys can respond to her regarding what you want to do if there's fees that are to be refunded. Obviously, half of them go to Mr. Houston. That's the easy part. The other half that was paid by mom may have to go to her estate.
Yes, Your Honor.
That's a very small amount, but that may be the thing.
They did split the fees. I wasn't.
They did split the fees 50-50. So any refund would be split 50-50. Mr. Houston gets his back.
Yes,
That's
thank you.
easy. But Ms. Prince will have to go to her estate. All right. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge.